Okay, let's unpack this. I mean, imagine you are running a tech startup, right? You don't have a physical office in Manila.
Right.
You have literally never even set foot in the Philippines. But your software, or maybe it's like a fitness app, it processes the personal data of Philippine citizens or residents.
Yeah, which is super common today.
Exactly. Well, what if I told you that if you mishandle that information, you could personally be on the hook for millions of pesos in fines and face actual physical prison time?
It's wild. It completely shatters that whole illusion that the internet is just this, lawless playground.
It really does.
People tend to think of data as this abstract, cloudy concept just floating around in the ether, but the legal framework surrounding it is made of brick and mortar, and it has some incredibly sharp teeth.
So true. And welcome to this deep dive, everyone. Today we are looking at the Philippine Data Privacy Act, but we're going to ask you to forget everything you know about boring standard issue compliance documents.
Please do.
Yeah, we are totally bypassing the legal jargon to uncover how this specific framework basically turns your digital footprint into highly guarded, legally enforceable property.
Which is exactly what it is.
Right. So for you listening, think of this as your ultimate shortcut to being well-informed. We are going to figure out exactly how your personal data is protected, who is held accountable, and the honestly, genuinely shocking penalties for those who try to play fast and loose with your information.
It is such a vital topic for anyone navigating the modern world. I mean, because every single time you click agree or every time you download an app or even just walk into a clinic to get a checkup, this legal architecture is actively working in the background.
Yeah, it governs what happens to your identity.
Yeah.
But I want to start with that hook, though, because the reach of this law is just wild.
It really is.
Before we get into how the data is protected, we have to establish where this law applies and who is actually enforcing it. Because that extraterritorial reached the idea that a completely foreign company can be held liable that sounds almost impossible to enforce.
It sounds like it, yeah, on paper.
Right. Looking at the framework, it seems the National Privacy Commission, or NPC, operates like a global data traffic cop. But I mean, can they really pull over a foreign company just for driving on the highway of Philippine citizens' data?
Well, if we connect this to the bigger picture, it actually makes perfect sense why they structured it this way.
How so?
We live in a borderless digital economy, right? If a data protection law only applied within physical national borders, it would be entirely useless.
Oh, because a company could just set up a server in a neighboring country.
Exactly. They could harvest citizen data from right across the border with zero consequences. So the law explicitly features extraterritorial application.
Okay.
It applies to any act done or practice engaged in, both inside and outside of the Philippines, as long as it relates to personal information about a Philippine citizen or a resident.
Okay, but how does the physical enforcement actually work? Like if I'm sitting in an office in Europe, how does the NPC actually reach me?
It really comes down to establishing a link.
Mm-hmm.
The legislation reaches you if your entity uses equipment located in the country, or if you have any form of central management, a branch, or even an agency in the Philippines.
Oh, so there has to be some physical tie, however small.
Right. But even beyond physical equipment, the NPC isn't just, sending angry letters into the void. They are an independent body with serious regulatory muscle. They are attached to the Department of Information and Communications Technology.
So they have actual backing.
Huge backing. They coordinate with international privacy watchdogs. If you violate the law, they can issue cease and desist orders. They can impose permanent bans on your ability to process data within the country, which essentially chokes out your market access.
Wow.
And they can recommend actual criminal prosecution to the Department of Justice.
Wait, criminal prosecution. So if an executive of that foreign company ever steps foot in a jurisdiction with a cooperative treaty, that theoretical prison time becomes a very real problem.
Exactly. A very real, very physical problem.
Okay, so they are not just an advisory board handing out warnings. They can cut off your business and put out a warrant. That makes the fundamental rules of the road incredibly important. So what is this watchdog actually looking out for?
Well, it's pretty foundational.
Looking at the framework, it seems to all boil down to a holy trinity of data processing principles: transparency, legitimate purpose, and proportionality. Which, honestly, that sounds like a total nightmare for modern tech companies.
Oh, it is. It's a massive culture shock for companies used to operating in the Wild West of data collection.
Because they just want to hoard everything.
Right. But those three pillars are the foundation of the whole system. Let's look at the mechanisms. First, transparency. This dictates that you, the data subject, must know exactly what is happening to your data, and it has to be explained in clear, plain language.
So companies can no longer hide behind 80 pages of microscopic legal jargon designed to confuse you.
Exactly. No more burying the lead.
Okay, and then legitimate purpose. I assume that means the data collection must not be contrary to law, morals, or public policy, right? You can't collect data to facilitate a scam.
Right, but it goes deeper than just avoiding crimes. It means the
Yeah.
company has to declare exactly why they need the information up front.
Okay.
But the third pillar, proportionality, this is where the real friction happens. It mandates that a company can only collect what is adequate, relevant, and entirely necessary for their declared purpose.
Meaning they cannot collect excessive data just because they feel like it.
Exactly.
But I have to push back on this a little bit, though. Isn't it incredibly tempting for companies to just claim that absolutely everything they collect might be necessary for some future, yet to be determined project?
Oh, they definitely try.
Like if I download a simple calculator app, the developer might say, oh, sure, we need your live location data and your entire browsing history because we might build a targeted coupon feature into the calculator 5 years from now.
Yeah, and it is a massive corporate instinct to hoard data just in case. I mean, data is the new oil after all.
Right.
But the law's internal rules actually anticipate this exact loophole. It explicitly outlaws the practice.
Really? How so?
The regulations dictate that personal data shall not be retained in perpetuity in contemplation of a possible future use.
Wow. So you cannot stockpile user data on a vague promise of future utility.
Nope. When the specific declared purpose you collected it for is fulfilled, the data must be securely destroyed.
That is a massive shift in power back to the user.
Huge shift.
Now, we also need to talk about the data itself, because this framework doesn't treat all data equally, does it? There's a strict hierarchy, specifically dividing personal information from sensitive personal information.
Right, and understanding that distinction is critical because it dictates how companies are allowed to treat you. So, personal information is broadly anything from which your identity is apparent or can be reasonably ascertained.
Like a name or a phone number, an
Sure,
address. But sensitive personal information, that's the stuff you really want under lock and key. The framework defines this as data about your race, ethnic origin, marital status, age, color, religious, or even political affiliations.
Yes, and it also includes your health and education records, your genetic or sexual life, and even any proceedings for alleged offenses.
It also specifically covers information issued by government agencies peculiar to an individual, right? Like social security numbers, driver's licenses, tax returns.
Yeah, all of that. And the philosophical logic here is really about vulnerability.
Okay, how so?
Well, if someone leaks your phone number, it's annoying, right? You get spam calls. But if someone leaks your genetic markers, your mental health history, or your tax returns, that can destroy your livelihood.
Oh, absolutely.
It can open you up to catastrophic discrimination or facilitate massive identity theft. Therefore, the rule is that processing sensitive personal information is strictly prohibited, period, unless the company meets very specific, narrow exemptions.
Like what? What's an exemption?
Primarily, explicit prior consent from the data subject. They have to ask you directly. Or, in extreme cases, if it's necessary to protect the life and health of a person who physically cannot give consent.
Oh, like an unconscious patient in an ER.
Exactly.
Okay, that brings up a term I keep seeing the sources that we should clarify before we go further. The law keeps putting all these strict limits on something called the personal information controller. What exactly makes a company a controller versus just a standard business?
It's an important distinction to make. A personal information controller is the person or organization who actually controls the collection, holding, processing, or use of the personal information.
Okay.
They're the ones pulling the strings and deciding the why and how of the data processing. This is distinct from a processor, which might just be like a third-party cloud server that the controller rents space from.
Got it. So the law targets the controller because they are the ones making the decisions about your digital life.
Precisely.
And because the law puts such strict limits on these controllers, it essentially takes the power and hands it right back to you, the listener. It gives you a powerful arsenal of rights.
It really does.
You have the right to be informed. You have the right to object to the processing of your data, which actually forces the controller to stop processing it. You have the right to access your data, to dispute inaccuracies and have them rectified immediately. You even have the right to be indemnified for damages if your data is used unlawfully.
Those foundational rights ensure you aren't just a passive product in this whole ecosystem.
But the two rights that really caught my eye are the right to erasure and the right to data portability. Erasure feels like a literal legal undo button.
Yeah, it kind of is.
The framework says that upon substantial proof, you can order a controller to suspend, withdraw, or completely destroy your personal data from their systems, like if it was unlawfully obtained, or if it's just no longer necessary for the purpose it was collected.
Yes, but it's even deeper than just an undo button for privacy. What's fascinating here is how the lawmakers anticipated the digital format of data through the right to data portability.
Right. I was trying to wrap my head around this one. Is data portability essentially like, okay, imagine you're switching doctors.
Okay.
Instead of starting from scratch and filling out a mountain of paperwork by memory in the waiting room, you can force your old doctor to hand over a neatly organized digital flash drive of your entire medical history. So you can just hand it directly to your new doctor.
That's a great way to look at it. That's the practical mechanism, but the logic behind it is entirely about preventing monopolies.
Interesting.
The lawmakers realized that holding data hostage is a classic anti-competitive tactic. When your personal information is processed electronically, you have the right to obtain a copy of that data in a structured, commonly used electronic format.
So they can't give it to you in some weird proprietary file type.
Right. The goal is to ensure that you aren't digitally locked into a single ecosystem. A company cannot hold your own history hostage just to make it incredibly inconvenient for you to switch to a competitor. You own the data, and you can take it with you.
That is so empowering. And you own it even after you're gone, apparently.
Yes.
The framework outlines a concept called transmissibility. These rights don't just die with you. Your lawful heirs can actually invoke all these data privacy rights after your death, or if you become incapacitated. It treats personal data almost like physical property in an estate.
Which highlights the intrinsic, almost tangible value of personal data. Having these rights on paper is fantastic, but as we know, data doesn't just live on paper.
Right, it lives on physical servers.
It's stored in databases, which requires controllers to physically and digitally protect that data.
Right, they have to build vaults. The law mandates reasonable and appropriate organizational, physical, and technical security measures. Companies need to designate specific data protection officers, they have to implement access management, and use encryption.
And when we look at the government, the vault doors get significantly heavier.
Oh, absolutely.
The regulations lay out highly specific numerical requirements for agency personnel who need to access sensitive personal information.
I noticed that. It's not just a general suggestion to, be careful. If a government employee wants to access sensitive personal info off-site, they can't just casually log in from a coffee shop.
Not at all.
They have to submit a formal request. And the head of the agency has exactly 2 business days to approve or disapprove it. And if the agency head does nothing, the request is automatically considered disapproved.
They essentially flipped the standard bureaucratic default.
Yeah. In many systems, inaction means it slips through the cracks and just happens. Here, inaction means the vault stays locked.
Right.
But the wild part to me is the limit. If it is approved, the employee is strictly limited to accessing no more than 1,000 records at a time, and it has to be secured using the highest encryption standards. Why exactly 1,000? It seems like such an arbitrary number.
Well, it's all about minimizing the blast radius.
Okay, the blast radius.
Think about it. If a government laptop is stolen at a coffee shop or an employee goes rogue, the lawmakers wanted to ensure the catastrophic damage is capped. 1,000 records is enough to do legitimate, targeted work, but it prevents an employee from downloading the entire national census onto a thumb drive and walking out the door.
That makes total sense. But things do go wrong. Vaults crack, hackers get in. And here's where it gets really interesting. The 72-hour rule.
Oh, this is a big one.
The framework dictates that if a breach occurs that compromises sensitive personal information or data that could enable identity fraud, the controller has exactly 72 hours upon knowledge of the breach to notify both the NPC and the affected data subjects.
And that ticking clock starts the moment they realize they have a problem, not when they solve it.
See, I have to push back here because 72 hours is an incredibly short window for a modern corporation.
It's extremely tight.
Like, if I'm managing an IT department and a massive ransomware attack hits our servers on a Friday night, within 72 hours, my team might barely know what servers are infected, let alone exactly whose data was stolen. What's stopping a panicked company from just concealing the breach to buy themselves a week to fix it? Do damage control, hire a PR firm before telling the authorities.
The law anticipates exactly that panic and that instinct to cover things up. The regulations do state that notification may be delayed, but only under incredibly strict conditions.
Like what?
You can delay it to determine the scope of the breach, to prevent further immediate disclosures, or to restore reasonable integrity to the system. You absolutely cannot delay it to draft a PR statement or to figure out how to save the CEO's job.
But even then, aren't they just shifting the goalposts? They could just say they were determining the scope.
That's where the enforcement comes in. It's not about forcing the company to fix the IT problem in 3 days. The underlying logic of the 72-hour rule is about victim mitigation.
Victim mitigation.
Oh, okay. If your social security number or banking details are stolen, every hour matters. The notification allows you, the victim, to freeze your credit, change your passwords, and monitor your accounts. When a company fails that 72-hour test and tries to conceal the breach to protect their own reputation, the law stops treating it as an unfortunate IT failure and starts treating it as a malicious criminal act.
Wow. So what does this all mean? It brings us to the most intense part of this deep dive, the price of negligence.
Yeah, the penalties.
We are talking about the actual penalties. This isn't just about a corporation paying a fine out of their petty cash fund, which we see happen in a lot of other countries, where data fines are basically just a cost of doing business. Under this framework, we are talking about individual prison time.
The penalties are severe, and they are assigned directly to the responsible officers who participated in the crime or, crucially, allowed the crime to happen by their gross negligence.
Let's run through these because the numbers are staggering. Unauthorized processing of personal information. 1 to 3 years in prison, plus fines up to 2 million pesos, if it's sensitive personal information. 3 to 6 years in prison, and up to 4 million pesos.
But pay very close attention to the clause regarding negligence.
Yeah.
Providing access to personal data without authorization because you were negligent carries the exact same prison sentences as doing it intentionally.
That blew my mind. Ignorance or sloppiness is no longer a defense. The one that really illustrates this is the penalty for improper disposal. The law states that knowingly or negligently disposing of personal information in an area accessible to the public or in a regular trash container is heavily penalized.
Which happens more often than you'd think.
Right. Let's put this into a real-world context. If you accidentally leave your private diary on a park bench, that is just an embarrassing personal mistake.
Yeah.
But if a corporate HR representative is cleaning out their office and leaves physical employee files in a public dumpster behind the building, it's not just a fireable offense, it is a literal jailable offense. 6 months to 3 years in prison.
It forces a massive structural change. The lawmakers made negligence equal to intent because they needed to force a cultural shift in how every single employee treats data.
Yeah.
A simple, oops, I left my system password on a sticky note on my monitor, or oops, I didn't shred these medical records before throwing them out, can theoretically put someone behind bars. When the stakes are that high, data security stops being just the IT department's problem and becomes everybody's problem.
And there are aggravating factors that make it even worse. If a breach or unauthorized processing affects the personal information of at least 100 people, it is considered large-scale, and the maximum penalty in the scale is automatically imposed.
Yes. They draw a hard line at 100 people, transitioning the crime from a localized incident into a mass casualty data event.
There are also specific consequences depending on who the offender is. This part fascinated me.
Oh, the alien and public official clauses?
Yes. If the offender is a foreign national and alien, they are deported without further proceedings after serving their sentence. And if the offender is a public officer, they suffer the accessory penalty of being disqualified from holding public office for a term double the term of their criminal penalty.
Why did the framers single out these two groups for extra punishment?
It really comes down to the philosophical concept of trust and privilege. A public officer is entrusted with the power of the state, right? They are stewards of the people's data.
Right. When they violate that privacy, it is a profound betrayal of public trust, hence the double disqualification. They have proven they cannot be trusted with public power. As for foreign nationals, they are guests operating under the hospitality of the host country's legal system. If they come in and exploit the citizens' most sensitive data, they have violated that hospitality and completely forfeit the privilege of remaining in the country.
The overarching message is unmistakable. I mean, handling someone else's personal data is a profound responsibility, and a breach of that trust is treated as a severe criminal act against the individual.
Absolutely.
This has been incredibly eye-opening. To wrap up, the sheer value of knowing this framework is massive for you as a listener. Your data is heavily guarded by strict principles of transparency and proportionality. You have rights that are transmissible to your heirs. You can demand your data in a portable format to prevent corporate monopolies. And companies, whether they are in Manila or halfway across the globe in Silicon Valley, face severe prison time and millions in fines for playing fast and loose with your information.
It entirely empowers the data subject. When you understand the architecture of your rights, you are no longer just passively generating data for corporations to harvest. You are actively protected by a system designed to hold powerful entities accountable.
But before we go, I want to leave you with one final, slightly provocative thought to mull over.
Okay.
We've spent this entire time talking about privacy as a fundamental, fiercely protected right. However, the framework explicitly states that the law does not apply to personal information processed for journalistic, artistic, literary, or research purposes. This exemption exists to uphold the freedom of speech, expression, and the press.
This raises an important question because it creates a fascinating legal and ethical collision course.
It's exactly. If data privacy is a fundamental right backed by the threat of prison, and freedom of expression is another fundamental right vital to a free society, where exactly will the battle lines be drawn in the future? What happens when a journalist or an artist's groundbreaking, culturally significant work relies entirely on exposing someone else's unconsented, highly sensitive personal data? When the immovable object of data privacy meets the unstoppable force of freedom of the press, which right wins? It's something to think about the next time you see a massive investigative leak in the headlines. Until then, remember, on the global highway of digital information, there really is a traffic cop, and they are definitely checking licenses. Keep your data safe out there.